Rule 116. Arraignment and plea. Section 1. Arraignment and plea, how made? A. The accused must be arraigned before the court where the complaint or information was filed or assigned for trial. The arraignment shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not guilty. The prosecution may call at the trial witnesses other than those named in the complaint or information. B. The accused must be present at the arraignment and must personally enter his plea. Both arraignment and plea shall be made of record, but failure to do so shall not affect the validity of the proceedings. C. When the accused refuses to plead or makes a conditional plea, a plea of not guilty shall be entered for him. 1a. D. When the accused pleads guilty but presents exculpatory evidence, his plea shall be deemed withdrawn and a plea of not guilty shall be entered for him. N. E. When the accused is under preventive detention, his case shall be raffled and its records transmitted to the judge to whom the case was raffled within 3 days from the filing of the information or complaint. The accused shall be arraigned within 10 days from the date of the raffle. The pre-trial conference of his case shall be held within 10 days after arraignment. N. F. The private offended party shall be required to appear at the arraignment for purposes of plea bargaining, determination of civil liability, and other matters requiring his presence. In case of failure of the offended party to appear despite due notice, the court may allow the accused to enter a plea of guilty to a lesser offense which is necessarily included in the offense charged with the conformity of the trial prosecutor alone. Sir 1-89. G. Unless a shorter period is provided by special law or Supreme Court circular, the arraignment shall be held within 30 days from the date the court acquires jurisdiction over the person of the accused. The time of the pendency of a motion to quash or for a bill of particulars or other causes justifying suspension of the arraignment shall be excluded in computing the period. Sector 2, Sir 38-98. Section 2. Plea of guilty to a lesser offense. At arraignment, the accused, with the consent of the offended party and the prosecutor, may be allowed by the trial court to plead guilty to a lesser offense which is necessarily included in the offense charged. After arraignment but before trial, the accused may still be allowed to plead guilty to said lesser offense after withdrawing his plea of not guilty. No amendment of the complaint or information is necessary. Sector 4, Sir 38-98. Section 3. Plea of guilty to capital offense, reception of evidence. When the accused pleads guilty to a capital offense, the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea and require the prosecution to prove his guilt and the precise degree of culpability. The accused may present evidence in his behalf. 3a. Section 4. Plea of guilty to non-capital offense, reception of evidence, discretionary. When the accused pleads guilty to a non-capital offense, the court may receive evidence from the parties to determine the penalty to be imposed. 4. Section 5. Withdrawal of improvident plea of guilty. At any time before the judgment of conviction becomes final, the court may permit an improvident plea of guilty to be withdrawn and be substituted by a plea of not guilty. 5. Section 6. Duty of court to inform accused of his right to counsel. Before arraignment, the court shall inform the accused of his right to counsel and ask him if he desires to have one. Unless the accused is allowed to defend himself in person or has employed a counsel of his choice, the court must assign a counsel de officio to defend him. 6a. Section 7. Appointment of counsel de officio. The court, considering the gravity of the offense and the difficulty of the questions that may arise, shall appoint as counsel de officio only such members of the bar in good standing who, by reason of their experience and ability, can competently defend the accused. But in localities where such members of the bar are not available, the court may appoint any person, resident of the province and of good repute for probity and ability, to defend the accused. 7a. Section 8. Time for counsel de officio to prepare for arraignment. Whenever a counsel de officio is appointed by the court to defend the accused at the arraignment, he shall be given a reasonable time to consult with the accused as to his plea before proceeding with the arraignment. 8. Section 9. Bill of Particulars. The accused may, before arraignment, move for a bill of particulars to enable him properly to plead and to prepare for trial. The motion shall specify the alleged defects of the complaint or information and the details desired. 10a. Section 10. Production or inspection of material evidence in possession of prosecution. Upon motion of the accused showing good cause and with notice to the parties, the court, in order to prevent surprise, suppression, or alteration, may order the prosecution to produce and permit the inspection and copying or photographing of any written statement given by the complainant and other witnesses in any investigation of the offense conducted by the prosecution or other investigating officers, as well as any designated documents, papers, books, accounts, letters, photographs, objects or tangible things not otherwise privileged, which constitute or contain evidence material to any matter involved in the case and which are in the possession or under the control of the prosecution, police, or other law investigating agencies. 11a. Section 11. Suspension of arraignment. Upon motion by the proper party, the arraignment shall be suspended in the following cases. A. The accused appears to be suffering from an unsound mental condition which effective renders him unable to fully understand the charge against him and to plead intelligently thereto. In such case, the court shall order his mental examination and, if necessary, his confinement for such purpose. B. There exists a prejudicial question, and c. A petition for review of the resolution of the prosecutor is pending at either the Department of Justice, or the Office of the President, provided, that the period of suspension shall not exceed 60 days counted from the filing of the petition with the reviewing office. 12a. Rule 117. Motion to quash. Section 1. Time to move to quash. At any time before entering his plea, the accused may move to quash the complaint or information. 1. Section 2. Form and contents. The motion to quash shall be in writing, signed by the accused or his counsel and shall distinctly specify its factual and legal grounds. The court shall consider no ground other than those stated in the motion, except lack of jurisdiction over the offense charged. 2a. Section 3. Grounds. The accused may move to quash the complaint or information on any of the following grounds. A. That the facts charged do not constitute an offense. B. That the court trying the case has no jurisdiction over the offense charged. C. That the court trying the case has no jurisdiction over the person of the accused. D. That the officer who filed the information had no authority to do so. E. That it does not conform substantially to the prescribed form. F. That more than one offense is charged except when a single punishment for various offenses is prescribed by law. G. That the criminal action or liability has been extinguished. H. That it contains averments which, if true, would constitute a legal excuse or justification, and I. That the accused has been previously convicted or acquitted of the offense charged, or the case against him was dismissed or otherwise terminated without his express consent. 3a. Section 4. Amendment of the complaint or information. If the motion to quash is based on an alleged defect of the complaint or information which can be cured by amendment, the court shall order that an amendment be made. 4a. If it is based on the ground that the facts charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion shall be granted if the prosecution fails to make the amendment, or the complaint or information still suffers from the same defect despite the amendment. N. Section 5. Effect of sustaining the motion to quash. If the motion to quash is sustained, the court may order that another complaint or information be filed except as provided in Section 6 of this rule. If the order is made, the accused, if in custody, shall not be discharged unless admitted to bail. If no order is made or if having been made, no new information is filed within the time specified in the order or within such further time as the court may allow for good cause, the accused, if in custody, shall be discharged unless he is also in custody for another charge. 5a. Section 6. Order sustaining the motion to quash not a bar to another prosecution, exception. An order sustaining the motion to quash is not a bar to another prosecution for the same offense unless the motion was based on the grounds specified in Section 3, G, and I, of this rule. 6a. Section 7. Former conviction or acquittal, double jeopardy. When an accused has been convicted or acquitted, or the case against him dismissed or otherwise terminated without his express consent by a court of competent jurisdiction, upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charged, or for any attempt to commit the same or frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charged in the former complaint or information. However, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information under any of the following instances. A. The graver offense developed due to supervening facts arising from the same act or omission constituting the former charge. B. The facts constituting the graver charge became known or were discovered only after a plea was entered in the former complaint or information, or C. The plea of guilty to the lesser offense was made without the consent of the prosecutor and of the offended party except as provided in Section 1, F, of Rule 116. In any of the foregoing cases, where the accused satisfies or serves in whole or in part the judgment, he shall be credited with the same in the event of conviction for the graver offense. 7a. Section 8. Provisional dismissal. A case shall not be provisionally dismissed except with the express consent of the accused and with notice to the offended party. The provisional dismissal of offenses punishable by imprisonment not exceeding 6 years or a fine of any amount, or both, shall become permanent 1 year after issuance of the order without the case having been revived. With respect to offenses punishable by imprisonment of more than 6 years, their provisional dismissal shall become permanent 2 years after issuance of the order without the case having been revived. N. Section 9. Failure to move to quash or to allege any ground therefor. The failure of the accused to assert any ground of a motion to quash before he pleads to the complaint or information, either because he did not file a motion to quash or failed to allege the same in said motion, shall be deemed a waiver of any objections based on the grounds provided for in paragraphs A, B, G, and I, of Section 3 of this rule. 8. Rule 118. Pretrial. Section 1. Pretrial, mandatory in criminal cases. In all criminal cases cognizable by the Sandiganbayan, Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court and Municipal Circuit Trial Court, the court shall after arraignment and within 30 days from the date the court acquires jurisdiction over the person of the accused, unless a shorter period is provided for in special laws or circulars of the Supreme Court, order a pretrial conference to consider the following. A. Plea bargaining. B. Stipulation of facts. C. Marking for identification of evidence of the parties. D. Waiver of objections to admissibility of evidence. E. Modification of the order of trial if the accused admits the charge but interposes a lawful defense, and F. Such other matters as will promote a fair and expeditious trial of the criminal and civil aspects of the case. SECS 2 and 3, Cert 38-98. Section 2. Pretrial agreement. All agreements or admissions made or entered during the pretrial conference shall be reduced in writing and signed by the accused and counsel, otherwise, they cannot be used against the accused. The agreements covering the matters referred to in Section 1 of this rule shall be approved by the court. Sector 4, Cert 38-98. Section 3. Non-appearance at pretrial conference. If the counsel for the accused or the prosecutor does not appear at the pretrial conference and does not offer an acceptable excuse for his lack of cooperation, the court may impose proper sanctions or penalties. SE 5, Cert 38-98. Section 4. Pretrial order. After the pretrial conference, the court shall issue an order reciting the actions taken, the facts stipulated, and evidence marked. Such order shall bind the parties, limit the trial to matters not disposed of, and control the course of the action during the trial, unless modified by the court to prevent manifest injustice. 3. Rule 119. Trial. Section 1. Time to prepare for trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial shall commence within 30 days from receipt of the pretrial order. Sector 6, Cert 38-98. Section 2. Continuous trial until terminated, postponements. Trial once commenced shall continue from day to day as far as practicable until terminated. It may be postponed for a reasonable period of time for good cause. 2a. The court shall, after consultation with the prosecutor and defense counsel, set the case for continuous trial on a weekly or other short-term trial calendar at the earliest possible time so as to ensure speedy trial. In no case shall the entire trial period exceed 180 days from the first day of trial, except as otherwise authorized by the Supreme Court. Sector 8, Cert 38-98. The time limitations provided under this section and the preceding section shall not apply where special laws or circulars of the Supreme Court provide for a shorter period of trial. N. Section 3. Exclusions. The following periods of delay shall be excluded in computing the time within which trial must commence. A. Any period of delay resulting from other proceedings concerning the accused, including but not limited to the following. 1. Delay resulting from an examination of the physical and mental condition of the accused. 2. Delay resulting from proceedings with respect to other criminal charges against the accused. 3. Delay resulting from extraordinary remedies against interlocutory orders. 4. Delay resulting from pretrial proceedings, provided that the delay does not exceed 30 days. 5. Delay resulting from orders of inhibition, or proceedings relating to change of venue of cases or transfer from other courts. 6. Delay resulting from a finding of the existence of a prejudicial question, and 7. Delay reasonably attributable to any period, not exceed 30 days, during which any proceeding concerning the accused is actually under advisement. B. Any period of delay resulting from the absence or unavailability of an essential witness. For purposes of this subparagraph, an essential witness shall be considered absent when his whereabouts are unknown or his whereabouts cannot be determined by due diligence. He shall be considered unavailable whenever his whereabouts are known but his presence for trial cannot be obtained by due diligence. C. Any period of delay resulting from the mental incompetence or physical inability of the accused to stand trial. D. If the information is dismissed upon motion of the prosecution and thereafter a charge is filed against the accused for the same offense, any period of delay from the date the charge was dismissed to the date the time limitation would commence to run as to the subsequent charge had there been no previous charge. E. A reasonable period of delay when the accused is joined for trial with a co-accused over whom the court has not acquired jurisdiction, or, as to whom the time for trial has not run and no motion for separate trial has been granted. F. Any period of delay resulting from a continuance granted by any court motu proprio, or on motion of either the accused or his counsel, or the prosecution, if the court granted the continuance on the basis of its findings set forth in the order that the ends of justice served by taking such action outweigh the best interest of the public and the accused in a speedy trial. Sector 9, Sir 38-98. Section 4. Factors for granting continuance. The following factors, among others, shall be considered by a court in determining whether to grant a continuance under Section 3, f, of this rule. A. Whether or not the failure to grant a continuance in the proceeding would likely make a continuation of such proceeding impossible or result in a miscarriage of justice, and b. Whether or not the case taken as a whole is so novel, unusual and complex, due to the number of accused or the nature of the prosecution, or that it is unreasonable to expect adequate preparation within the periods of time established therein. In addition, no continuance under Section 3, f, of this rule shall be granted because of congestion of the court's calendar or lack of diligent preparation or failure to obtain available witnesses on the part of the prosecutor. Sector 10, Sir 38-98. Section 5. Time limit following an order for new trial. If the accused is to be tried again pursuant to an order for a new trial, the trial shall commence within 30 days from notice of the order, provided that if the period becomes impractical due to unavailability of witnesses and other factors, the court may extend it but not to exceed 180 days from notice of said order for a new trial. Sector 11, Sir 38-98. Section 6. Extended time limit. Notwithstanding the provisions of Section 1, G, Rule 116 and the preceding Section 1, for the first 12 calendar month period following its effectivity on September 15, 1998, the time limit with respect to the period from arraignment to trial imposed by said provision shall be 180 days. For the second 12-month period, the limit shall be 120 days, and for the third 12-month period, the time limit shall be 80 days. Sector 7, Sir 38-98. Section 7. Public Attorney's duties where accused is imprisoned. If the public attorney assigned to defend a person charged with a crime knows that the latter is preventively detained, either because he is charged with a bailable crime but has no means to post bail, or is charged with a non-bailable crime, or is serving a term of imprisonment in any penal institution, it shall be his duty to do the following. A. Shall promptly undertake to obtain the presence of the prisoner for trial or cause a notice to be served on the person having custody of the prisoner requiring such person to so advise the prisoner of his right to demand trial. B. Upon receipt of that notice, the custodian of the prisoner shall promptly advise the prisoner of the charge and of his right to demand trial. If at any time thereafter the prisoner informs his custodian that he demands such trial, the latter shall cause notice to that effect to send promptly to the public attorney. C. Upon receipt of such notice, the public attorney shall promptly seek to obtain the presence of the prisoner for trial. D. When the custodian of the prisoner receives from the public attorney a properly supported request for the availability of the prisoner for purposes of trial, the prisoner shall be made available accordingly. Sector 12, Sir 38-98. Section 8. Sanctions. In any case in which private counsel for the accused, the public attorney, or the prosecutor, a. knowingly allows the case to be set for trial without disclosing that a necessary witness would be unavailable for trial, b. files a motion solely for delay which he knows is totally frivolous and without merit, c. makes a statement for the purpose of obtaining continuance which he knows to be false and which is material to the granting of a continuance, or d. willfully fails to proceed to trial without justification consistent with the provisions hereof, the court may punish such counsel, attorney, or prosecution, as follows. 1. By imposing on a counsel privately retained in connection with the defense of an accused, a fine not exceeding 20,000 pesos, P20,000.00. 2. by imposing on any appointed counsel de officio, public attorney, or prosecutor a fine not exceeding 5,000 pesos, P5,000.00, and 3. By denying any defense counsel or prosecutor the right to practice before the court trying the case for a period not exceeding 30 days. The punishment provided for by this section shall be without prejudice to any appropriate criminal action or other sanction authorized under these rules. Sector 13, Sir 38 to 98. Section 9. Remedy where accused is not brought to trial within the time limit. If the accused is not brought to trial within the time limit required by Section 1, G, Rule 116 and Section 1, as extended by Section 6 of this rule, the information may be dismissed on motion of the accused on the ground of denial of his right of speedy trial. The accused shall have the burden of proving the motion, but the prosecution shall have the burden of going forward with the evidence to establish the exclusion of time under Section 3 of this rule. The dismissal shall be subject to the rules on double jeopardy. Failure of the accused to move for dismissal prior to trial shall constitute a waiver of the right to dismiss under this section. Sector 14, Sir 38 to 98. Section 10. Law on speedy trial not a bar to provision on speedy trial in the Constitution. No provision of law on speedy trial and no rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial guaranteed by Section 14, 2, Article 3, of the 1987 Constitution. Sector 15, Sir 38 to 98. Section 11. Order of trial. The trial shall proceed in the following order. A. The prosecution shall present evidence to prove the charge and, in the proper case, the civil liability. B. The accused may present evidence to prove his defense, and damages, if any, arising from the issuance of a provisional remedy in the case. C. The prosecution and the defense may, in that order, present rebuttal and surrebuttal evidence unless the court, in furtherance of justice, permits them to present additional evidence bearing upon the main issue. D. Upon admission of the evidence of the parties, the case shall be deemed submitted for decision unless the court directs them to argue orally or to submit written memoranda. E. When the accused admits the act or omission charged in the complaint or information but interposes a lawful defense, the order of trial may be modified. 3a. Section 12. Application for examination of witness for accused before trial. When the accused has been held to answer for an offense, he may, upon motion with notice to the other parties, have witnesses conditionally examined in his behalf. The motion shall state, a. The name and residence of the witness, b. The substance of his testimony, and c. That the witness is sick or infirm as to afford reasonable ground for believing that he will not be able to attend the trial, or resides more than 100 kilometers from the place of trial and has no means to attend the same, or that other similar circumstances exist that would make him unavailable or prevent him from attending the trial. The motion shall be supported by an affidavit of the accused and such other evidence as the court may require. 4a. Section 13. Examination of defense witness, how made. If the court is satisfied that the examination of a witness for the accused is necessary, an order will be made directing that the witness be examined at a specified date, time, and place, and that a copy of the order be served on the prosecutor at least 3 days before the scheduled examination. The examination shall be taken before a judge, or, if not practicable, a member of the bar in good standing so designated by the judge in the order, or if the order be made by a court of superior jurisdiction, before an inferior court to be designated therein. The examination shall proceed notwithstanding the absence of the prosecutor provided he was duly notified of the hearing. A written record of the testimony shall be taken. 5a. Section 14. Bail to secure appearance of material witness. When the court is satisfied, upon proof or oath, that a material witness will not testify when required, it may, upon motion of either party, order the witness to post bail in such sum as may be deemed proper. Upon refusal to post bail, the court shall commit him to prison until he complies or is legally discharged after his testimony has been taken. 6a. Section 15. Examination of witness for the prosecution. When it satisfactorily appears that a witness for the prosecution is too sick or infirm to appear at the trial as directed by the order of the court, or has to leave the Philippines with no definite date of returning, he may forthwith be conditionally examined before the court where the case is pending. Such examination, in the presence of the accused, or in his absence after reasonable notice to attend the examination has been served on him, shall be conducted in the same manner as an examination at the trial. Failure or refusal of the accused to attend the examination after notice shall be considered a waiver. The statement taken may be admitted in behalf of or against the accused. 7a. Section 16. Trial of several accused. When two or more accused are jointly charged with any offense, they shall be tried jointly unless the court, in its discretion and upon motion of the prosecutor or any accused, orders separate trial for one or more accused. 8a. Section 17. Discharge of accused to be state witness. When two or more persons are jointly charged with the commission of any offense, upon motion of the prosecution before resting its case, the court may direct one or more of the accused to be discharged with their consent so that they may be witnesses for the state when, after requiring the prosecution to present evidence and the sworn statement of each proposed state witness at a hearing in support of the discharge, the court is satisfied that a. There is absolute necessity for the testimony of the accused whose discharge is requested. b. There is no other direct evidence available for the proper prosecution of the offense committed, except the testimony of said accused. c. The testimony of said accused can be substantially corroborated in its material points. d. Said accused does not appear to be the most guilty, and e. Said accused has not at any time been convicted of any offense involving moral turpitude. Evidence adduced in support of the discharge shall automatically form part of the trial. If the court denies the motion for discharge of the accused as state witness, his sworn statement shall be inadmissible in evidence. 9a. Section 18. Discharge of accused operates as acquittal. The order indicated in the preceding section shall amount to an acquittal of the discharged accused and shall be a bar to future prosecution for the same offense, unless the accused fails or refuses to testify against his co-accused in accordance with his sworn statement constituting the basis for the discharge. 10a. Section 19. When mistake has been made in charging the proper offense. When it becomes manifest at any time before judgment that a mistake has been made in charging the proper offense and the accused cannot be convicted of the offense charged or any other offense necessarily included therein, the accused shall not be discharged if there appears good cause to detain him. In such case, the court shall commit the accused to answer for the proper offense and dismiss the original case upon the filing of the proper information. 11a. Section 20. Appointment of acting prosecutor. When a prosecutor, his assistant or deputy is disqualified to act due to any of the grounds stated in Section 1 of Rule 137 or for any other reasons, the judge or the prosecutor shall communicate with the Secretary of Justice in order that the latter may appoint an acting prosecutor. 12a. Section 21. Exclusion of the public. The judge may, motu proprio, exclude the public from the courtroom if the evidence to be produced during the trial is offensive to decency or public morals. He may also, on motion of the accused, exclude the public from the trial, except court personnel and the counsel of the parties. 13a. Section 22. Consolidation of trials of related offenses. Charges for offenses founded on the same facts or forming part of a series of offenses of similar character may be tried jointly at the discretion of the court. 14a. Section 23. Demurrer to evidence. After the prosecution rests its case, the court may dismiss the action on the ground of insufficiency of evidence, 1. On its own initiative after giving the prosecution the opportunity to be heard or, 2. Upon demurrer to evidence filed by the accused with or without leave of court. If the court denies the demurrer to evidence filed with leave of court, the accused may adduce evidence in his defense. When the demurrer to evidence is filed without leave of court, the accused waives the right to present evidence and submits the case for judgment on the basis of the evidence for the prosecution. 15a. The motion for leave of court to file demurrer to evidence shall specifically state its grounds and shall be filed within a non-extendable period of 5 days after the prosecution rests its case. The prosecution may oppose the motion within a non-extendable period of 5 days from its receipt. If leave of court is granted, the accused shall file the demurrer to evidence within a non-extendable period of 10 days from notice. The prosecution may oppose the demurrer to evidence within a similar period from its receipt. The order denying the motion for leave of court to file demurrer to evidence or the demurrer itself shall not be reviewable by appeal or by certiorari before judgment. N. Section 24. Reopening. At any time before finality of the judgment of conviction, the judge may, motu proprio or upon motion, with hearing in either case, reopen the proceedings to avoid a miscarriage of justice. The proceedings shall be terminated within 30 days from the order granting it. N. Rule 120. Judgment. Section 1. Judgment definition and form. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition on him of the proper penalty and civil liability, if any. It must be written in the official language, personally and directly prepared by the judge and signed by him, and shall contain clearly and distinctly a statement of the facts and the law upon which it is based. 1a. Section 2. Contents of the judgment. If the judgment is of conviction, it shall state, 1. The legal qualification of the offense constituted by the acts committed by the accused and the aggravating or mitigating circumstances which attended its commission. 2. The participation of the accused in the offense, whether as principal, accomplice, or accessory after the fact. 3. The penalty imposed upon the accused, and 4. The civil liability or damages caused by his wrongful act or omission to be recovered from the accused by the offended party, if there is any, unless the enforcement of the civil liability by a separate civil action has been reserved or waived. In case the judgment is of acquittal, it shall state whether the evidence of the prosecution absolutely failed to prove the guilt of the accused or merely failed to prove his guilt beyond reasonable doubt. In either case, the judgment shall determine if the act or omission from which the civil liability might arise did not exist. 2a. Section 3. Judgment for two or more offenses. When two or more offenses are charged in a single complaint or information but the accused fails to object to it before trial, the court may convict him of as many offenses as are charged and proved, and impose on him the penalty for each offense, setting out separately the findings of fact and law in each offense. 3a. Section 4. Judgment in case of variance between allegation and proof. When there is variance between the offense charged in the complaint or information and that proved, and the offense as charged is included in or necessarily includes the offense proved, the accused shall be convicted of the offense proved which is included in the offense charged, or of the offense charged which is included in the offense proved. 4a. Section 5. When an offense includes or is included in another. An offense charged necessarily includes the offense proved when some of the essential elements or ingredients of the former, as alleged in the complaint or information, constitute the latter. And an offense charged is necessarily included in the offense proved, when the essential ingredients of the former constitute or form a part of those constituting the latter. 5a. Section 6. Promulgation of judgment. The judgment is promulgated by reading it in the presence of the accused and any judge of the court in which it was rendered. However, if the conviction is for a light offense, the judgment may be pronounced in the presence of his counsel or representative. When the judge is absent or outside of the province or city, the judgment may be promulgated by the clerk of court. If the accused is confined or detained in another province or city, the judgment may be promulgated by the executive judge of the regional trial court having jurisdiction over the place of confinement or detention upon request of the court which rendered the judgment. The court promulgating the judgment shall have authority to accept the notice of appeal and to approve the bail bond pending appeal, provided, that if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed and resolved by the appellate court. The proper clerk of court shall give notice to the accused personally or through his bondsman or warden and counsel, requiring him to be present at the promulgation of the decision. If the accused tried in absentia because he jumped bail or escaped from prison, the notice to him shall be served at his last known address. In case the accused fails to appear at the scheduled date of promulgation of judgment despite notice, the promulgation shall be made by recording the judgment in the criminal docket and serving him a copy thereof at his last known address or through his counsel. If the judgment is for conviction and the failure of the accused to appear was without justifiable cause, he shall lose the remedies available in these rules against the judgment and the court shall order his arrest. Within 15 days from promulgation of judgment, however, the accused may surrender and file a motion for leave of court to avail of these remedies. He shall state the reasons for his absence at the scheduled promulgation, and if he proves that his absence was for a justifiable cause, he shall be allowed to avail of said remedies within 15 days from notice. 6a. Section 7. Modification of judgment. A judgment of conviction may, upon motion of the accused, be modified or set aside before it becomes final or before appeal is perfected. Except where the death penalty is imposed, a judgment becomes final after the lapse of the period for perfecting an appeal, or when the sentence has been partially or totally satisfied or served, or when the accused has waived in writing his right to appeal, or has applied for probation. 7a. Section 8. Entry of judgment. After a judgment has become final, it shall be entered in accordance with Rule 36. 8. Section 9. Existing provisions governing suspension of sentence, probation, and parole not affected by this rule. Nothing in this rule shall affect any existing provisions in the laws governing suspension of sentence, probation, or parole.